It was 9:47 on a Tuesday morning, and Tasha Perez was doing what millions of Americans do without a second thought, loading groceries into the back of her SUV after a routine weekly shop. The kind of morning that doesn't register in memory. The kind of morning that disappears into the week without leaving a mark. This one was about to leave a mark that would last a lifetime. She was reaching for the last paper bag, oranges, bottled water, a box of cereal sitting on top, when she felt it before she saw it. That particular shift in the air that combat veterans learn to read before their conscious mind catches up. She turned, and there they were. 3 men in all-black tactical gear moving across the parking garage with the kind of deliberate, practiced formation that doesn't belong in a Tuesday morning grocery run. Behind them, Bue's 2 black vehicles sat parked at angles that were less coincidental and more calculated. One of the men was already pointing at her. No introduction, no badge display, no explanation. Just a finger and a voice that cut through the ambient noise of a suburban mall parking garage like a blade. Don't move. What happened in the next 9 minutes would detonate across the country like a slow-burning charge that someone had been laying for 14 years without realizing it. It would end a federal career. It would trigger a congressional investigation. It would put a man in federal prison. And it would put a woman's name on a piece of legislation that rewrote the rules of federal law enforcement from the ground up. What started as a Tuesday morning grocery run is about to become one of the most consequential 9 minutes in federal law enforcement history. Stay with me. This one gets darker before it gets satisfying. And if you're new here, hit subscribe. We cover the cases that demand to be told. Carl Davies was the kind of man that institutions create when they stop paying attention. 14 years in federal law enforcement. 3 prior complaints buried so efficiently in his personnel file that you'd have needed a specific reason to look for them. And until that Tuesday morning, no one had been given one. He was not a rogue agent in the cinematic sense. He was something more mundane and more dangerous. A man who had been allowed, year after year, to operate just inside the boundary of accountability. Sulking, and who had gradually stopped being able to locate that boundary at all. He was wearing all-black tactical gear on a Tuesday morning outside a suburban mall, and he moved toward Tasha Perez with the unhurried certainty of a man who had never once been wrong about how one of these situations would end. He had run this calculation before. He would approach. He would project authority. The person on the receiving end would comply, because that was how it went. That was how it always went. He told her not to move. She didn't move. But she set down the grocery bag she was holding with a deliberateness that was itself a kind of answer. Slow, controlled, the movement of someone who is choosing every action consciously and with full awareness of what it communicates. Then she turned to face him completely. Now then she looked at him with an expression that he would later struggle to describe in his own deposition. Not hostility, not fear. Something flatter and more impenetrable than either. Tasha Perez had done 2 combat deployments as a United States Navy SEAL. She had made operational decisions in environments where the wrong call didn't mean a reprimand. It meant a body bag. She had developed, through years of training and 2 theaters of active conflict, a capacity for stillness under pressure that most people will never be required to access. Carl Davies, in a mall parking garage on a quiet Tuesday morning with his tactical gear and his pointing finger, did not come close to registering on that scale. "I need you to identify yourself," she said, "and provide a warrant." Her voice was level, not raised, not shaking, not performatively calm in the way of someone working hard to suppress panic. Just level, the way a surgeon's hands are steady not because they are suppressing trembling, but because steadiness is simply who they are now. Davies did not identify himself beyond a flash of credentials so brief it barely registered. He did not produce a warrant. He did not articulate probable cause or explain the legal basis for the stop. He told her again to comply, and this time he stepped closer and his 2 officers moved with him, fanning out around her in a flanking position that was textbook pressure formation. The kind of positioning designed to make the subject feel surrounded, outnumbered, overwhelmed. The kind of positioning designed to compress a person's sense of options until compliance feels like the only exit. Oh, it did not compress Tasha Perez's sense of options in the slightest. She told him her full name. She told him her rank. She told him she was a United States Navy SEAL, that she had served 2 combat deployments, that she possessed an honorable service record, and that she had a thorough and specific understanding of her Fourth Amendment rights and had no intention of waiving them. She told him that her hands were visible, had been visible, and would remain visible, and that she was going to need him to either produce a warrant or articulate a lawful basis for this stop before this conversation went any further. Davies stared at her. There was a long moment, 3 seconds, maybe 4, captured in crystalline clarity on multiple cameras, where something moved behind his eyes that was not procedure and was not protocol. It was the specific friction of a man who has built his entire professional identity around the assumption of compliance encountering, for perhaps the first time, someone who simply wasn't going to provide it. Not out of defiance, not out of aggression, out of knowledge. Out of the settled, unshakable knowledge of her own rights. He told her one more time to put her hands where he could see them. She already had. They had been where he could see them the entire time. Every camera in that garage, and there were more of them than Carl Davies had bothered to notice, would later confirm it frame by frame. What happened next took less than 4 seconds. 4 seconds that Carl Davies will carry for the rest of his life like a stone sewn into his chest. He had run out of procedure. That was the truth of it. Now stripped of every layer of institutional language and legal framing, he had no warrant. He had no articulable probable cause. He had no legal scaffolding of any kind to justify why he had crossed that parking lot, why he had surrounded a woman who was loading groceries, why he had positioned his officers in a formation designed to intimidate. What had brought him to this woman's vehicle was not evidence. What had brought him to this vehicle was a description, vague, incomplete, and applied with a speed and certainty that had nothing to do with the description and everything to do with the woman standing in front of him. She had not folded. Every other calculation he'd made that morning had failed. And so, in the space between one breath and the next, Carl Davies reached for the only thing he had left. He said it quietly, "Oftak," almost under his breath. The way people say things they have said before in spaces where they believed there were no consequences. In back offices, in patrol cars, in locker rooms, in all the places where the version of yourself you show to oversight doesn't follow you in. The slur dropped into the air between them like something with physical weight. Tasha Perez went very still. Not the stillness of someone absorbing a blow. The stillness of someone who has just watched their opponent make a catastrophic, unrecoverable, completely self-inflicted mistake, and is already, with the same operational clarity she applied to everything else, calculating the distance between this moment and its consequences. What Carl Davies did not know, could not have known, because he had not bothered to look before he opened his mouth, was that he had set it on camera, not one camera, 3 separate cameras, capturing 3 separate angles, each with audio clean enough to require no enhancement and no interpretation. The mall's fixed security array had a direct, unobstructed sightline to his face and his mouth. A woman 20 feet away had been recording on her phone since the moment she saw the tactical vehicles park at those strange, deliberate angles. And a man standing near the elevator bank in a gray overcoat had his phone raised, his jaw set, and his finger on the record button, and had been filming continuously and steadily for the past 6 minutes without Carl Davies once looking in his direction. The slur was already evidence before Davies finished saying it. It was already time-stamped. It was already being backed up to a cloud server on a phone that Diane Marsh's 17-year-old daughter was clutching with both hands. It was already beyond the reach of any internal affairs process, any damage control memo, any after-the-fact incident report written to describe events differently than they had occurred. Carl Davies had just gift-wrapped a federal civil rights case and handed it with a bow on it to opposing counsel, and he was still standing in the parking garage, still believing, with the deep and now utterly hollow confidence of 14 years, that he was in control of this situation. He was not in control of anything. He just didn't know it yet. The man near the elevator bank was the Honorable Raymond Stokes, retired United States District Court judge, 31 years on the federal bench. And a man who had presided over enough civil rights cases, enough police misconduct hearings, enough attempts to dress up institutional failure in the laundered language of proper procedure, that he had developed a near-instant recognition for what he was seeing the moment he saw it. He had recognized it the moment the tactical vehicles pulled in at those angles. He had recognized it in the positioning of the officers as they fanned out around Tasha. He had recognized it in Davies' body language, the forward lean, the deliberate proximity, the refusal to engage with her questions. He had raised his phone before Davies had finished his first sentence, and he had not lowered it once. He was not the only one. Diane Marsh had come to the mall with her teenage daughter to return a pair of shoes. And she was the kind of woman who noticed things, who had, over decades of living in the world as a black woman, developed a finely calibrated sense for when something ordinary was about to become something else entirely. She had started recording when she saw the officers fan out. Her daughter, 17 years old and operating with the social media instincts of her generation, had her own phone recording 30 seconds later and was already thinking about where she was going to post it before the confrontation had reached its midpoint. Gerald Foote, the mall's on-duty security officer, was a retired county sheriff's deputy with 22 years of his own law enforcement experience. He knew exactly what a warrantless stop looked like from the inside of the system, and he knew exactly what it looked like from the outside. When he moved to within 15 feet of the confrontation, kept his phone level and his hand steady, and filmed every second without interfering, because he understood that the most useful thing he could do in this moment was document it. A couple loading their own car 2 rows over stopped what they were doing. A delivery driver on his route paused and pulled out his phone. A college student who had been eating lunch on a parking barrier watched the scene unfold and decided, with the quiet, moral clarity that sometimes cuts through the noise when the situation is obvious enough, that this was something that needed to exist on video. By the time Carl Davies finally stepped back, by the time the confrontation wound down and the officers retreated to their vehicles and Tasha Perez stood alone again beside her open trunk, 7 independent recordings existed. Shot from 7 different positions, 7 different angles. The complete 9 minutes captured with an overlap and redundancy that made the prospect of any successful counter-narrative essentially impossible before one had even been attempted. Some of the recordings had audio so clean you could hear Tasha's measured, controlled breathing in the silences between sentences. One of them had captured the slur with a clarity that a forensic audio analyst would later testify required 0 enhancement at standard playback volume. Judge Raymond Stokes walked directly to his car, sat down in the driver's seat, and called a former colleague in the federal public defender's office. He described what he had witnessed with the same precise, unembellished, chronologically sequential language he had used from the bench for 31 years. His colleague told him to preserve the footage immediately and not to speak to anyone from Davies' agency without legal representation present. Stokes told him he was already ahead of him on both counts. Tasha Perez loaded the last of her groceries, closed the trunk of her SUV, and drove home. She sat in her driveway for a long time before she went inside, long enough that her neighbor, who was walking a dog past the house, later said she had seemed like someone who was finishing a calculation before she was willing to move. Then she went inside, she made coffee, and she called her lawyer. The clip that Diane Marsh's daughter posted at 11:23 that Tuesday morning was 47 seconds long. It was not the most complete footage of the 9-minute confrontation. It was not the clearest audio. It captured a fragment, a window, a slice of what had happened in that parking garage, and it was more than enough. It showed a black woman standing beside an open car trunk full of groceries, hands visible, voice calm, identifying herself as a Navy SEAL, asking with a patience that was itself a form of indictment for a warrant that never came. And it showed Carl Davies in his tactical black, responding with a word that no camera angle, no metadata dispute, no carefully worded incident report was ever going to explain away. By noon, it had 200,000 views. The number is almost meaningless in isolation. 200,000 is the kind of figure that can feel abstract until you remember that it represents 200,000 individual people sitting with their phones or their laptops, watching 47 seconds of a parking garage in a suburban mall, and feeling something move in their chest. By 3 in the afternoon, it had crossed 1 million. By the time the dinner hour arrived on the East Coast, Carl Davies' name had become a search term, and the results were not flattering. His name was appearing in sentences alongside his badge number, his agency affiliation, his field office location, and a personnel file that his supervisors had, until approximately 48 hours ago, believed was safely and permanently buried in the administrative sediment of a large federal bureaucracy. It was not safely buried. It had never been safely buried. It had simply been sitting in a system that no one had been sufficiently motivated to excavate, because Carl Davies had never before done something public enough and documented enough and undeniable enough to make the excavation worth the effort. Now it was worth the effort. Now journalists, researchers, advocacy organizations, and private citizens with time and internet access were all digging at once. And what they found was not a surprise to anyone who had filed one of the 3 prior complaints that were now being read in full and discussed in detail across every major platform simultaneously. 3 complaints. 2 from members of the public who had been stopped without sufficient legal basis. 1 from a fellow agent, a colleague who had since transferred to a different field office and who, when reached by a journalist at 6:47 that evening, declined to make an on-record comment but also did not deny the complaint's existence, which in the specific grammar of that particular non-denial said everything it needed to say. The complaints described not dramatic, headline-ready incidents but a quieter and more persistent pattern. The kind of low-grade, deniable, systemic bias that institutional processes are specifically engineered to absorb before it becomes visible. The kind that accumulates in personnel files and sits there, and sits there, and sits there, until one Tuesday morning, when a man in tactical gear makes the mistake of saying something into the face of 3 recording devices simultaneously. Davies' supervisors had stopped answering their phones by early afternoon. The agency's public affairs office released a 3-sentence statement confirming the incident was under review and encouraging patience while the process unfolded. It satisfied no one. It was not designed to satisfy anyone. It was designed to exist, to occupy the space where accountability should be, while the gears of institutional self-protection ground slowly into motion. By midnight, 2 sitting United States senators had publicly called for a federal investigation into the incident. By the following morning, a 3rd had introduced the request in formal writing. The footage, meanwhile, had been downloaded, mirrored, screen-recorded, archived, and then distributed across so many independent platforms and private servers that it had become effectively indestructible. The kind of evidence that exists beyond the reach of any deletion request ever submitted, because for every copy removed, 40 more had already propagated outward into the permanent record. Carl Davies woke up on Wednesday morning to discover that the country had learned his name while he was sleeping, and that absolutely nothing about how it had learned it was going to work in his favor. The agency moved fast, and it moved with the practiced efficiency of an institution that had navigated public relations crises before. Within 72 hours of the footage reaching 40 million views, a formal incident report had been filed internally characterizing the stop as part of an active, ongoing, warrant-backed federal operation. The language in the report was careful, the kind of careful that takes time and editorial attention to achieve. It articulated probable cause. It described reasonable suspicion with statutory precision. It referenced supporting documentation in a way that implied a clean, procedurally sound operation that had simply been mischaracterized by incomplete footage and emotional public reaction. The problem, as it turned out, was the metadata. A paralegal working late on a Thursday night, cross-referencing the newly submitted warrant documentation against the timestamps in the agency's own internal filing system, found a discrepancy that was not subtle. The warrant paperwork bore a creation date and time that placed it comfortably, legitimately, prior to the incident in the parking garage. The underlying system metadata, however, the kind of timestamp that gets generated automatically by software and cannot be manually adjusted without leaving evidence of the adjustment, told a different story entirely. A story in which the document had been created, formatted, edited, and uploaded to the system 19 hours and 43 minutes after Tasha Perez had driven out of that parking garage and gone home. Someone had miscalculated, had trusted the wrong person to handle the technical side of the falsification, had moved too quickly under the pressure of a situation that was escalating faster than the cover-up could keep pace with. And in that haste, they had made the kind of mistake that doesn't look like a mistake until someone patient enough to look finds it, and then it looks like exactly what it is. Scharfwitz and finer bias. The memo came to light through a whistleblower, An agency employee who had watched the footage on their personal phone on Tuesday evening like everyone else in the country, who had gone to bed that night already knowing what they were going to be asked to do when they arrived at work the next morning, and who had made a decision somewhere in the dark hours before their alarm went off about what kind of person they were going to be. They did not sign the document they were asked to process. They made a copy first. They consulted a private attorney. And within 7 days, the copy was in the hands of a federal prosecutor who had already been quietly building a preliminary file since day 3 of the public firestorm. The cover-up had become a second crime, clean and documentable, stacked directly on top of the first. It was, in the end, in the classic failure mode of institutions under pressure, the attempt to contain damage that instead multiplies it. Whoever had authorized that memo had handed the prosecution a supplementary case that required almost no additional construction. The gift had been accepted. The file had been expanded, and the number of people whose careers were now in the trajectory of this thing had grown considerably beyond Carl Davies alone. Tasha Perez gave one interview before the trial. A single, carefully chosen, precisely controlled 42 minutes of television that the country watched with the specific attention that comes when someone says something that cannot be dismissed, deflected, or mischaracterized without the mischaracterization being immediately obvious. She chose the outlet with the deliberateness she applied to everything. She set her terms in advance, and she arrived in her full Navy dress uniform, service medals aligned on her chest with geometric precision, posture carrying the particular upright stillness of someone who has spent years in environments where your bearing is itself a form of communication. She did not raise her voice once. She did not reach for emotion, did not perform distress, did not ask the audience for sympathy or solidarity or outrage. She understood, with the same tactical intelligence she had applied to operations in 2 combat theaters, that none of those things were what this moment required. What this moment required was precision, clarity, the systematic, sequential, statute-by-statute dismantling of every procedural justification that had been attempted on Carl Davies' behalf. So that is what she delivered. She named the Fourth Amendment violation by its statutory citation. She walked through the sequence of events in the parking garage in chronological order, identifying each moment at which the stop transitioned from legally ambiguous to legally indefensible. She described the slur not as a personal wound, though it was, but as a data point. Evidence, one more element in a documented sequence that she had organized in her mind with the same operational care she had applied to planning missions in Kandahar. She noted, without inflection and without editorial, that her hands had been visible throughout the entire 9-minute encounter, that she had complied with every lawful instruction, and that the number of lawful instructions actually issued during those 9 minutes was 0. The country sat down and listened. Not because she was performing, not because she was angry, she wasn't, or at least she was not allowing anger to occupy the foreground of this particular broadcast. The country sat down and listened because she was right, and she knew she was right with a completeness and a sureness that came through the screen like a signal, and she was not asking anyone's permission to say so. The interview was watched by 48 million people in its first week. Clips of specific moments from it were watched by considerably more. It was the kind of testimony that forecloses certain arguments simply by existing, that makes the subsequent attempt to characterize Tasha Perez as anything other than exactly what she was, a decorated veteran with a detailed and accurate command of her constitutional rights, but not just difficult, but actively self-defeating for anyone who tried. The subpoenas arrived on a Wednesday morning, delivered with the quiet efficiency of a committee that had decided very early on that this was not a situation that warranted the usual deliberative pace. Carl Davies received his. His 2 accompanying officers received theirs. 4 supervisors in the chain of command above the field operation, including the field office director who had reviewed and signed off on the incident report that was now the subject of a separate obstruction inquiry, received theirs. The speed at which the House Judiciary Committee had moved told anyone paying attention something important about what the committee chair had seen when she watched the footage, and what she had concluded about the kind of institutional failure it represented. Tasha Perez received an invitation, not a subpoena. The distinction was deliberate, and the committee's communications office made certain it was understood as such by every outlet that covered the hearing's scheduling. She was not a subject of the inquiry. She was not a witness to her own misconduct. She was the person to whom an injustice had been done, and she was being asked, not compelled, to sit before the committee and describe it in her own words, in a formal chamber of power, on the record, with the full weight of congressional process behind every word. She accepted. The hearing was scheduled for a Tuesday, 6 weeks to the day from the morning in the parking garage. Washington, which had a long and practiced relationship with high-profile congressional hearings that generated substantial noise and modest consequence, today was bracing in a way that felt different this time. Because this time, the evidence was not disputed. This time, there was footage, multiple angles, clean audio, no interpretive ambiguity. There was a backdated memo with a metadata trail a paralegal had found in an evening's work. There was a whistleblower who had already spoken to prosecutors. There was a retired federal judge who had watched the entire confrontation from 15 feet away and had 31 years of bench experience to bring to his description of what he had seen. And there was a woman in a Navy uniform who had already demonstrated in 42 minutes of national television that she was more prepared, more precise, and more constitutionally literate than anyone who was going to be sitting across from her in that chamber. Davis' attorney filed a motion the night before the hearing requesting a postponement on grounds that the pre-hearing publicity had made fair proceeding impossible. The motion was denied before the building opened the next morning. The trial lasted 3 weeks, and the prosecution conducted it with an economy and confidence that comes from having more than enough. They did not need to be theatrical. They did not need to construct a narrative from fragments and inference. The evidence was complete, corroborated, and mutually reinforcing to a degree that left the defense with very little to work with beyond procedural objection and the hope that repetition might dull impact. On the first day, they played the parking garage footage, not the 47-second clip, all of it, every angle, every camera. With the full 9 minutes from the moment Carl Davies crossed the parking lot to the moment he stepped back and the confrontation wound down. They played it in sequence, then they played specific segments with annotations, and then they played it again. The jury watched in silence throughout. Several of them would later describe the experience of seeing the footage on a large courtroom screen, in full, unedited, without the compression of a phone display, of being inside those 9 minutes rather than scrolling past them, as qualitatively different from watching it on their own devices, more present, more unavoidable. The slur was played 3 times at the jury's specific request during the deliberation phase. The foreperson in a post-verdict interview, Ice was careful to note that it had not been the deciding factor so much as the confirmation, the moment that made coherent and legible everything else they had already spent 3 weeks absorbing. The backdated memo entered evidence on day 8. The prosecution's forensic technology expert, a former federal investigator with 18 years of experience in digital evidence analysis, spent 4 disciplined hours walking the jury through the metadata discrepancy. She used plain language. She used visual aids. She used the kind of patient, thorough, assumption-free explanation that leaves a jury with no ambiguity and no available exit. The defense objected 17 times during her testimony. They were overruled 17 times. The memo's author, Ikran, who had by day 11 entered into a cooperation agreement with federal prosecutors that reduced his own exposure substantially in exchange for complete and unambiguous testimony, took the stand and described what he had been asked to do and what he had done with a specificity and a lack of self-serving editorializing that the jury appeared to find more credible, not less, for its starkness. Davies' prior complaints entered the record on day 14, read aloud by the lead prosecuting attorney in a tone so flat and deliberate and free of theatrical inflection that the content was allowed to land without interference. Each complaint, each date, each description of each prior incident. The jury had been watching Carl Davies sit at the defense table for 2 weeks. They had seen the footage. They had seen the memo. But they had heard the testimony. They were not, by day 14, confused about the nature of the pattern being described or the man at its center. The jury deliberated for 4 hours. They returned to the courtroom with guilty verdicts on all 3 counts: unlawful detention, violation of civil rights under color of law, and obstruction of justice for the falsified documentation. Davies received the verdict without visible reaction, a stillness that read, in the context of everything that had preceded it, less like composure and more like the specific blankness of a man who has run entirely out of road. His attorney requested the verdict be polled. Each juror confirmed it individually. 12 voices, 12 times. In a courtroom that had been waiting for this moment since a Tuesday morning 6 weeks earlier, and when a man in tactical gear said something into the face of a camera he hadn't bothered to notice. The sentencing came 30 days after the verdict, and it was conducted with the same quiet thoroughness that had characterized the trial. Carl Davies received 4 years in federal prison. He was stripped of his pension. 14 years of federal service contributions gone. His credentials were permanently revoked. He was barred from any future employment in federal law enforcement for the remainder of his life. The judge in delivering the sentence noted that the severity was not punitive beyond what the law prescribed, but that the particular nature of the violation, a federal agent using the authority of his office to circumvent the very constitutional protections that office exists to uphold, made leniency indefensible. Davies' supervising officer, who had authorized the backdated warrant documentation, received 18 months and a career-ending formal censure. 2 others in the supervisory chain received formal sanctions and were required to resign. The field office director who had signed off on the original incident report without it emerged, having reviewed the underlying documentation, received a formal reprimand and was reassigned to a non-supervisory role pending a separate internal review. Tasha Perez settled her civil suit against the agency for $3,800,000. She did not hold a press conference. She did not give a statement to camera on the courthouse steps. She released 3 paragraphs in writing through her attorney's office. Extowing. That thanked her legal team and every witness who had been present in that parking garage and had chosen to record what they saw. The final paragraph noted, precisely and without sentiment, that the outcome of the case should not be understood as a resolution, that it was, instead, a beginning. She was right. She was, as had become something of a pattern over the previous several months, right? The Perez Constitutional Enforcement Act had been introduced in the Senate 8 weeks after the parking garage footage first went public, moving with a bipartisan momentum that reflected both the clarity of the underlying incident and the political calculation of legislators who had watched 40 million people watch that 47-second clip. It was drafted with substantive input from Judge Raymond Stokes. He's co-sponsored by 11 senators from both parties and built around 3 central provisions: a requirement for documented, independently reviewable probable cause before any warrantless stop conducted by a uniformed federal agent, mandatory body camera activation as a legal precondition for any enforcement action, and the establishment of an independent civilian oversight process for complaints filed against federal field agents, a mechanism that in a detail that itself said something significant about the state of things had not existed in any formal, enforceable capacity prior to the Act's passage. It passed the Senate 94-6. It passed the House with a comparable margin. The president signed it into law on a Thursday afternoon in the East Room, in a ceremony that was brief and efficient and carried, sent for those in the room, the specific weight of something that should have happened long before it did. Tasha Perez stood in the 3rd row. Full Navy dress uniform. Service medals in their correct order on her chest. Hands folded in front of her. The same expression she had worn throughout all of it. Through the parking garage, through the television interview, through the congressional hearing, through 3 weeks of trial. Composed, present, clear-eyed, and entirely unsurprised that it had come to this, because she had known from the moment she set down that grocery bag and turned to face Carl Davies that if she remained exactly who she was, the outcome was inevitable. That was the thing about being right. When you stayed right and you stayed standing, and you did not give the institution the chaos it needed to justify looking away, eventually it had nowhere left to look. She had survived 2 wars in foreign countries. She had survived 9 minutes in a parking garage in suburban America that, in its own way, had asked as much of her as either of them. She had survived the long, grinding, paper-intensive effort of institutions working to protect themselves at the direct expense of the person they had harmed. And she had come out the other side with her name on a federal law, a law that would govern how federal agents interacted with American citizens for as long as it stood. Carl Davies is in federal prison. Tasha Perez's name is on a federal law. And somewhere out there, agents who thought their badges made them untouchable are reading the Perez Constitutional Enforcement Act and understanding for the first time that accountability has been written into the rules. If this story moved you, if it made you think, made you angry, made you proud, or made you want to share it with someone who needs to hear it, do that right now. Share this video. It takes 3 seconds and it matters more than you think. Drop your reaction in the comments below. I read every single one. And if you're not subscribed yet, fix that right now, because we have more stories like this one coming, and you don't want to be the person who finds out about them 2 weeks late. Hit the bell. We'll see you in the next one.